Hello all and welcome to our Managing Charity Property event. Obviously today marks the 1-year anniversary of going into lockdown, an event that's led to us all continually re-evaluating over the past year the property we have and how we use it. Well, today, combining the expertise of Buzzacott, King and Gerald Eve, this event is going to provide you with an essential update on the accounting, legal and property management issues that you need to be aware of. But before we begin, I just want to cover off some virtual housekeeping. Firstly, as webinar guests, your cameras and microphones are off, but you can ask questions at any time throughout the webinar via the Q&A box on your screens. Additionally, we are recording the session and a copy of the recording as well as the slides will be sent to you via email after the event. Now, in terms of our agenda for today, I'm your host, Tim Rutherford from Stone King, and throughout the event we'll hear from Paul Greenwood and William Ray of Gerald Eve, Catherine Williams and Hugh Pearce of Stone King, and Amanda Francis and Socrates of Buzzacott. And we'll then conclude the event with a Q&A session, and any questions that we don't get the chance to cover off and answer live will be answered with a written follow-up. So without further ado, I'll pass on to Paul, who's going to start this session off with an update on the state of the property market. Paul.
Thanks, Tim. Morning all. My name's Paul Greenwood. I'm a partner in the alternative markets team at Gerald Eve. For those of you that joined the same webinar last year, we tried to predict the implications that COVID-19 pandemic could have on the property sectors that would affect religious charities. And at that time, I don't think any of us thought that we'd be sat here presenting from home sort of a year on from now through a screen with almost the same haircut as I had last year. As you well know, the government has relied heavily on charities throughout the pandemic for help delivering food, medical care, mental health support and housing support. I know from speaking to a number of charities that most are expecting an increase in demand in their services over the next few months as restrictions are lifted. However, despite this increasing demand for support, like most organisations, the reality of the lockdown and subsequent restrictions have had a huge impact on income. Dwindling financial reserves, redundancies and reductions in services are becoming more prevalent than ever. Charities will be an essential part of our economic recovery and rebuilding of our society post-COVID. Therefore, it's crucial that charities ensure that their properties are able to support their charitable objectives, as there could be an opportunity to reinforce charities' relevance and attract new funding streams. It's therefore imperative to be as prepared as possible and to think carefully about your property strategies to ensure that they're still fit for purpose and achievable. Therefore, planning ahead now to allow for these changes will help future-proof your estates, which my colleague Will Ray will discuss further with you next. If you could just move on to the next slide, just looking at the sort of economic position very sort of generally and at a high level, it's difficult to predict the financial and operational implications of the outbreak of COVID-19 on the UK economy or the organisations which operate within it. And I think, as we'll probably all agree, last year finished on a slightly more positive note than we all expected, with I think progress with both the COVID vaccines and also the UK and EU avoiding a no-trade deal Brexit. It's expected that the economic hit of the third lockdown should be smaller than the first one, and Oxford Economics GDP is expected to fall by 4.4% in Q1 relative to Q4 in 2020. The greater threat, however, for the property market is that the current paralysis will be followed by a broader economic downturn when the state-offered business loans and furlough schemes come to an end. Both investors and occupiers fear that we're not yet over the worst, and it comes the impacts on the real estate sector. Reviewing this sort of forward-looking matrix, sort of both internally, sort of in the press, I think we'll all agree over the next 12 months that both capital and rental values there are indications that they will fall to a varying degree across most property sectors in the short term. We're seeing opportunistic investors and overseas capital keen to access assets, sensing an opportunity, and there are some signs of distress on the sell side in the charity and faith group owned property sectors. We don't expect the market to improve materially in the short term, and there's no certainty that the market will have improved by the spring or perhaps even into the summer when the government support packages may have started to reduce. Just moving on to the next slide, just looking at the residential market, just very briefly. Surprisingly, and as you'll all agree, the UK housing market has held up relatively well, despite the prevailing economic conditions. Since last July, the housing market's generally been on the rise, largely fueled by the government temporarily cutting stamp duty. And we're beginning to see a clearer picture of the impact of the coronavirus has had on the house prices. But with the ongoing stamp duty holiday and continuing lockdown measures, the figures and forecasts could continue to fluctuate. The most reliable barometer of house prices in the land is the Land Registry's UK House Price Index, which is based on sold prices. And the Land Registry has recorded that the average price of a property in the UK increased by 1.2% month on month last year and 8.5% year on year in December. Although the residential market seems to be defying gravity now, some analysts anticipate that the rate of growth will slow when the stamp duty holiday comes to an end, but its recent extensions have given pause for thought. The letting market appears to remain relatively robust so far. However, as the market continues to be impacted by both restrictions on movement, economic uncertainty, and by the changes in the way transactions investments are taxed and regulated, there are signs of the market beginning to weaken. We could just move on to the development market. The key constraint on housing delivery, market conditions aside, is generally the availability of land, of which there's usually a fundamental shortage, and therefore generally a strong demand in prime locations. The sector has become increasingly crowded over recent years, and with cheap debt and still readily available and increased competition, developers are still bidding competitively and looking at alternative ways to reduce costs in order to provide a competitive edge. Partnerships with landowners and developers continue to play an important role, often providing opportunities to unlock sites that otherwise would not have come forward, thereby accelerating delivery and often spreading the risk for the developers while increasing value for the landowner. As a general rule, charities should be wary of entering into joint ventures with developers, as property sales are governed by the Charities Act, requiring open marketing and best terms. However, there are some exemptions from this, including disposal to another charity for terms otherwise than for the best price. Also, for some disposals of ecclesiastical properties or those charities governed by the Universities and Colleges Estates Act 1925, or when accommodation or facilities are re-provided for the charity as part of the scheme, or where charities are retaining part of the land and disposing of the surplus element. As I'm sure you're all aware, there are fiduciary duties of the trustees to act prudently and not to expose themselves to sales or development risks as they're not developers, but in certain situations, if the transaction is carefully structured, it can be an innovative way for charities to create new purpose-built facilities, wholly funded through additional development on the site, using the developer's expertise to maximise the development potential and the capital receipt achievable. We're currently involved in a number of re-provision developments on behalf of predominantly religious orders for parish halls and new community facilities wholly funded through airspace development above, which is enabling the charities to meet their future charitable objectives. Despite the uncertainties of the economic outlook, there's still a relatively strong demand for land in well-located areas, and we're seeing some softening of resale prices, increased build costs and protracted sales periods negatively impacting upon land pricing in subprime areas. It's the quality of the purchaser and the level of due diligence carried out that's crucial in this market, as deliverability becomes ever more important in these uncertain times. Just moving on to the next slide on the community market, or community use market. Until the 1st of September 2020, as you may or may not be aware, there was a part of the sort of planning reform use class order that community use properties, which we've always regarded as sort of D1 properties under the previous use class order, are now form part of a slightly sort of new labelled use class, which is known as F1, which currently excludes nurseries. Nurseries have been moved over into use class E, which is a new use class that's been set up, which includes more commercial uses. So those religious orders that own sort of say church halls or community use properties that are being exclusively used by nurseries, that they may wish to consider putting forward applications for CLUIDs, certificates of lawful existing use, just to preserve and protect their interest, to just in case the tenants make their own sort of applications on their behalf. We're currently involved, I mean, owners of, just moving forward, as planning policy always strongly influences demand for community use properties, as local authorities in most cases will resist the loss of any community space as part of any change of use or redevelopment, unless the provision is being re-provided elsewhere within the borough. From our experience, the market is highly price sensitive to issues around condition and refurbishment costs, which can have a significant impact on pricing, and purchasers are generally far more enthusiastic to secure properties in good locations rather than anywhere secondary. We're finding that as religious charities' finances have been constrained by the pandemic, that there's been a noticeable drive towards the rationalisation of activities, and charities are actively disposing of their property assets at cost-saving measure to help repay their COVID debts to shore up their future, which again my colleague Will Ray will discuss with you in a bit more detail in the following meeting. We've also noticed an uptick in charitable mergers. Just finally, just to sort of cover off some of the other sort of alternative markets. I mean, it's difficult within 10 minutes, as I'm sure you appreciate, to cover all the markets, but I thought it might be helpful just to touch on the education and healthcare markets for those that own or operate properties in the sector. Based on our extensive direct experience in the education market since the COVID-19 crisis emerged, the sector has not previously experienced such stress, and at the same time, we've not seen so many prospective purchasers. Market activity would appear to indicate that operators foresee a reasonable, stable demand for independent schooling. However, on the other hand, the challenge of the affordability of fees whilst running sustainable businesses in a competitive environment will remain. We're aware of over 10 independent schools that closed last year or are being driven to market as a necessity to seek to continue trading, as the problems facing struggling schools pre-COVID, particularly in the charity sector, have been exacerbated by COVID-19. We're experiencing that the buyer pool for independent schools is reducing, and the predictability of pricing is less certain, and delivery risks have increased. The healthcare market has been at the forefront of the pandemic. In a year that has changed the course of history, the toll of more than 40,000 coronavirus deaths in the UK care homes has deterred many families from sending loved ones who could be cared for at home. Plunging occupancies caused by COVID and falling fees from council is threatening the viability of some private operators. And it was reported earlier this month that the UK's largest care home provider, HC1, has made the decision to sell 52 of its facilities and to focus on more specialised care and a move towards more high dependency care for people with complex dementia and other needs. The sector is under enormous pressure at the moment, at a time when our population is not ageing relatively well. And without reform and direction, the care market will only deteriorate further. I hope you found this useful. Clearly, I'd obviously be pleased to answer any questions that you may have in the Q&A, and I'll pass you on now to my colleague Will, who will provide you with an overview of changes in the alternative markets relevant to you. Thank you very much.
Thank you, Paul. Nice to see you, or not see you, so to speak. It'd be nice to be able to hold one of these events in front of people sooner or later, because I must say it is getting a bit much working from home personally for me, and also, like Paul, I also need a haircut. There's a lot to cover over the next 10 minutes. I don't want to go into, I'm not able to go into too much detail, but I'm going to touch in a bit more detail on some of the trends which Paul's highlighted. I'll be looking at some of the things which charities can be doing with their estate, as well as some opportunities for charities. And then I'm going to cover two case study examples of current projects which we're working on at the moment, and I think would be interesting to you. So next slide, please, Rebecca. Thank you. So in terms of the trends, as religious charities, you do occupy and own a number of different properties, so it's quite difficult to focus this talk on the particular trends which you may be seeing. I think it is relevant to say that we are seeing a lot more working from home, and this doesn't just apply to charities. It's everybody. it has proved to be a success for most, and I think the result or the impact of working from home and the success of working from home is yet to be fully seen. But we are expecting to see a rationalisation of office or administrative space for the sector, as well as more widely in the non-charity markets. For example, I think most office occupiers are carefully looking at the way in which they return to the office, and most are reporting sort of 2 to 3 days a week in the office, and that's obviously going to have an impact upon demand for administrative or office space in the sector. HSBC, whilst not a charity, for example, they are looking to reduce their office stock globally by about 40% going forward. So that's a sign of things to come, we believe. As a result of working from home, we are expecting to see some migration away from more expensive city centres, both in terms of support space as well as living accommodation, particularly for those charities who maybe have historic connections to those locations, but not necessarily operational properties still existing. Again, we think this is going to result in some rationalisation and consolidation in the sector. We've also started to see and see requests from a number of our religious charity clients for us to look at ways to dispose of surplus residential property, whether that be single flats or larger convents. And I don't necessarily consider this to be a trend as a result of COVID, but we expect that over the last year, vacant property has become more prominent, and charities are having to look at the way in which they occupy their premises, and it is ultimately resulting in some consolidation for communities to come together and surplus space coming forward. And like I say, I think this is going to increase as we move out of the pandemic. In terms of trading operations, as Paul mentioned, we are seeing sadly some marginal trading operations looking to close. Again, I don't necessarily see this as a direct result of the pandemic, but more so downward trends being exacerbated by the pandemic. In terms of surplus space and office spaces as such, we are seeing more charities looking to exit from administrative space, and again, it's been a result of watching that sit vacant for the last year. In terms of requirements going forward, we are expecting to see more of an emphasis on energy efficient buildings and more flexible, light and airy space for those that do need to secure new premises or indeed undertake works to their own premises. Sadly, we are seeing property exits taking longer, whether that be through disposals or mergers, etc. We are generally seeing purchasers being more risk averse, and sadly it's a sign of the times when the markets get difficult. Purchasers tend to do more due diligence, and I'm going to touch on a bit more detail on that in the slides to come. Paul's already touched on some of the planning changes and the particular relevance to church halls. If we can move on slides, please. So what can you be doing from a property perspective? I think we always go on about it, but it's very important to be on top of your estate strategy and make sure that your property is working for you correctly. We are starting to see charities paying more attention to their estates, which is refreshing, and we are being approached rather than the other way around in some circumstances. If you don't have an estate strategy, then we recommend that one is put in place. It needs to be regularly reviewed and updated, and now is a good time to look at the way that you occupy property, both for operational needs and in terms of the way that you live as well. if there are some efficiencies to be made, then it's worth trying to implement these, which can often result in surplus property, which can be used to generate income or extract capital. Now, if you are identifying property which is surplus to requirements, then selling isn't your only option available to you, and we are increasingly seeing charities looking at leasing as a potential way to fill some of the gaps which have been created over the last year in terms of the shortfall in income for charities due to the pandemic. Not all charities benefit from the ability to be able to lease their space, but some will be sat on good quality property in good locations, which is suitable for leasing. And if you can secure a good covenant, then there can be benefits to the value of your property, and the value can be potentially enhanced over and above vacant possession values. I think Amanda's going to touch on this in a bit more detail, but I just want to say, whilst income generation from property can appear attractive, there needs to be a fine balance between managing that strategy appropriately. It can be a burden on trustees to become landlords, and it needs to be balanced carefully about what are actually your objectives from an exit from property. Extracting capital from property, we really mean sales of freeholds or leaseholds, and if you are looking to dispose of an interest in property, whether it be leasing or selling, then you need to make sure that you are complying with the requirements of the Charities Act, which as of yesterday have been updated, and we're expecting to see some changes come forward, and I think Hugh or Catherine are going to touch on some of those points as we move forward through this webinar. If you are looking at your estate, you need to make sure you plan ahead. Property is illiquid; it does take a long time to deal with property, and it always takes longer than you anticipate. If you are looking for an exit, then we recommend that you undertake suitable pre-sale due diligence and liaise with your professional team to see what is required. As I mentioned earlier, we are seeing a number of buyers being more risk averse, more conditions attached to offers, greater investigations into the property as part of the contractual process. So if there are matters which can be addressed at an early stage through pre-sale due diligence, then that may well be in your interests to speculate more time and more costs up front to make the exit more simple going forward. I think when you're also looking at operational property in particular, there is often, it's very difficult to exit from operational properties, and if a property is on an operational property such as a school or a care home is on a downward trend, then it's clear decisions may need to be made quickly before that can have a negative impact upon the value of the property and the options for you. We've got here build projects, build and refurbishment projects, and I think if you are looking to undertake such projects, then you need to be critically reviewing whether that is still within your interests. If you do have a property which is on a downward trend, for example, should you be investing in the extension or a new sports hall or new tennis courts, for example, for a school when it's not necessarily going to add to your operation, and you need to make sure that you are using your charitable resources carefully. And I said it before, but make sure that your property works for you, and that you don't adjust the way that you operate and live just to suit your property. Next slide, please. I just wanted to talk through two examples of projects which we're working on at the moment. I appreciate that looking at bullets on a screen is not quite as exciting as looking at a nice picture. So hopefully at least that that will be seen favourably. On the left, St James Church in Ealing, we've been instructed by the LDF to dispose of an interest in this property, which has sat vacant for a few years. The reason I've chosen this as an example is that the LDF are looking to generate income from this property rather than capital receipts, because it's felt that is more beneficial to the continued operation. We've not yet started marketing. Marketing will begin within the next week or so on this property, and we are expecting to see some demand. I think there are backup options if a lease or a tenant can't necessarily be identified, in terms of looking at potentially longer leases, but a freehold sale is very unlikely with this particular property. Morehouse, South Kensington, on the right hand side, is a property which we've been involved with for the last probably 18 months or so. It is a student centre in South Kensington opposite the Natural History Museum. It was operational it's owned by a religious order, and it was operational up until the spring last year, when lockdown brought forward its closure. It's not been run with a profit motive, and whilst you can't see it from the picture, it is in need of significant investment, and it has been in need of such for some years now. The charity have been looking at their options for some time, and their options have been to look at refurbishing the property and undertaking significant investment to be able to continue to operate it. But it was felt that with ageing numbers and an increasingly competitive marketplace, would they be best placed to be able to do this. We've also looked at options in terms of a freehold or leasehold disposal for them, and potentially management agreements. The difficult decision was made to exit from the property, and it was brought to the market in September last year. It's expecting to go through shortly. I think this is an interesting example of a charity who have for some time known that they needed to act. They have looked at their options very, very carefully and made an informed decision, which will ultimately mean that they are released from what would otherwise be, in my opinion, a burden to them, and released in valuable funds which can be reinvested into missions elsewhere, as well as supporting the community going forward. So a bit of a whirlwind tour through. Like Paul, I'll be happy to take any questions at the end, but otherwise I'm now going to hand over to Catherine, who's going to talk about how the pandemic has affected property law.
Good morning, everyone. Thank you very much, Will. So I'm going to take a look at how property law has changed over the last 12 months in response to the pandemic. I think the main legal changes have been in relation to residential and commercial leases, and effectively the laws changed to make it much harder for evictions to take place. So if we go on to the next slide, please. I'm going to look at residential tenancies first. I should say, when I talk about a residential tenancy, I'm talking about an assured short hold tenancy or an AST. They're the most common forms of residential tenancy, although there are other types. I think it's probably worth thinking about the policy reasons for the change in the law, and I think it was recognised very early on when we first went into the lockdown that lots of people were going to face quite significant disruption to their income streams, and so we're going to struggle to pay their rent, and that coupled with the health policy of we didn't want people moving around trying to find accommodation, and in the worst case scenario people being made homeless. So the law was changed to effectively change the notice periods that landlords needed to give to tenants. So normally, to end an assured short hold tenancy where there hasn't been any breach by the tenant, a landlord would give 2 months notice. That was increased to 3 months and then extended again. So the current notice requirement is 6 months. If a tenant had been in breach of an AST, then pre-COVID, a landlord could have got away with us giving as little as 2 weeks notice to a tenant. Again, that's been extended to 6 months, save in relation to the most serious cases, so where there's either antisocial behaviour or rent arrears of at least 6 months. In addition to that, normally once the landlord had served notice, the tenant would then leave at the end of the notice period, but if they didn't, then a landlord would go to court and start possession proceedings for an eviction notice. Again, those all new and ongoing possession proceedings are on hold, and an eviction notice will only ever be issued in serious circumstances, so where there's domestic abuse, very serious rent arrears, or illegal occupation. And the government's current guidance is they're not expecting evictions to restart until mid-June. So that's positions in relation to residential. If we could move to the next slide. Again, like residential tenancies, commercial leases, there's also restrictions on terminating leases. And again, the policy reasons for that were, again, a recognition that commercial tenants would face quite significant financial disruption. I think also a position that they didn't want landlords going after tenants for rent if that was potentially going to force the tenant company into some sort of liquidation, and the knock-on consequences of that for jobs. And also an idea that once we come out of this and the economy restarts, these businesses need somewhere to trade from. So the law introduced a prohibition on landlords taking steps to terminate leases for non-payment of rent. If you're looking in a lease, that's normally called the forfeiture or the re-entry clause. And broadly, to terminate a lease for non-payment of rent, a landlord would either peacefully re-enter the property and effectively change the locks, or more commonly, they'd go to court and start forfeiture proceedings. There's a prohibition on using either of those steps. Originally, that was until the 30th of June 2020, but as you can see, as the pandemic progressed, the extensions were made, and the latest deadline is the 30th of June 2021. Also, like residential tenancies, there's a stay on all system claims that are currently in the system. In addition to that, there's a moratorium on landlords issuing statutory demands or winding up petitions against tenants. So pre-COVID, if the landlord had a debt owed to it, it could issue a process whereby it would actually kind of go after the tenant entity and look to sort of wind it up. There's a prohibition on that until the 31st of March 2021, but commentators are expecting that deadline to be extended until the 30th of June, so it's in line with the other restrictions. Now, I should say, whilst there's a prohibition on a landlord terminating the lease for non-payment of rent, that doesn't mean that the tenant's obligation to pay rent doesn't continue. So the tenant is still obliged to pay rent in accordance with the lease. It's just that the landlord doesn't have much recourse or enforcement action. So come the 1st of July 2021, if there is unpaid rent, then the landlord could sue the tenant for that, and depending on the extent of the arrears, also take steps to terminate the lease. So if we move on to the next slide, because of that, there's been a lot of discussions between landlords and tenants about payment of rent. And in the webinar we did last year, we sort of focused on this and the different types of arrangements that landlords and tenants might come to. So we've got things like rent holidays, rent reductions, rent deferrals, so where rent isn't payable for say April and May, but then come June, the rent starts being repaid, as well as the unpaid rent. We've also had tenants requesting changes in their rent payment dates, so some tenants preferring to say pay monthly to help with their cash flow. And we've also had lease variations. So typically they've been where a tenant's got a right to break, and it's been agreed that that will be removed from the lease in exchange for some sort of rent concession, so either a rent-free period or a rent reduction. So whilst this is not a new area of property law, there's been a lot more, I'd say, action, and if you've got tenants, you've probably had some sort of discussion with them about how they've been paying rent over the last year. If we can move on to the next slide, please. I'm not going to go into health and safety too much, so I'm not a health and safety lawyer, but it's obviously just to say there's been a lot of guidance on COVID secure working, and this is actually an area where we've seen quite a lot of collaboration between landlords and tenants, particularly where there's shared areas or lots of tenants in a building, and they've all had to come together to decide how staircases have been designated, hand sanitizing units, how lifts are going to be used. So again, that's an area where not really changes in the law, but sort of more collaboration than we'd previously seen. And I guess the last area that I wanted to pick up on, and which as a property lawyer is extremely exciting, is the introduction of electronic signatures in property transactions. I should say electronic signatures, it's not where you just copy and paste your signature that you might have on your desktop onto a piece of onto a document. It's where you sign a document using a secure website platform. And it's not a new concept in law, but in property, it's very rarely been used, and that's because the Land Registry has never accepted it as a legal form of signing documents, which is why I as a property lawyer have always had to send you paper documents with a requested a wet ink signature, so on leases, property transfers, legal charges, etc. And I think the pandemic highlighted sort of how awkward that process had come, particularly where we had people in different locations. We had, situations where people were having to sign documents in the garden, on car bonnets, particularly where they need to be witnessed. And I think that just pushed the Land Registry to review its guidance. And in July 2020, it announced it would now start accepting electronically signed documents, which is quite exciting and new. Just a couple of points to say. First of all, it's a completely optional way of signing documents. So if paper documents and wet ink signatures work for you as a charity, or you have trustees that particularly like that way of signing, then that's absolutely fine. It's just that this is now an option which we never previously had. Second point to make is your constitution needs to permit you to sign things electronically, or I guess at most not prohibit you from signing documents electronically. And the third thing, just to sort of flag, is that it's still relatively new guidance. So lawyers and I guess clients are still getting used to it as a form of execution. So it can't be used in every transaction because both parties need to agree to use it. And at the moment, there's a little bit of ambiguity from the Land Registry about signing documents with a seal. So at the moment, the Land Registry's guidance isn't very clear that they'll accept electronic seals. So if you're a charity that would normally sign with a seal and 2 trustees, then we're probably going to have to continue with a paper-based signature process for the time being. So that was a run through the changes over the last 12 months. I'm now going to pass you on to Hugh to look at future changes in property law.
Many thanks, Catherine. And if we can go to the next slide, please. So, yes, what's coming? This is a little review, firstly, of some what I describe as pure property things to anticipate in the coming months, years. And then on the second slide, I'll go on to some other related, but not pure property matters. And first off, it wouldn't be a webinar that I was involved with if I didn't mention the Law Commission report. And I fully expected just to say that, and that was it today. But lo and behold, what timing is immaculate, in as much as yesterday, the government has in fact responded to the Law Commission's report. So I can actually say a little bit more than I expected, delightfully, on this particular topic. I'll just do a very, very, very swift rundown on some of the sort of highlighted points, if I may. The broad aspect of which is that the government has largely agreed to what the Law Commission recommended, and you've probably heard me speak about before if you've attended any webinar I've been involved with in recent years. But there are 1 or 2 points where they haven't agreed. So just quickly running down the sort of headline points on the property aspects. First one, as you may recall, is the proposal from the Law Commission that there should be simplification of who could give the qualified surveyor's report, in fact, sort of widening of those who could give the qualified surveyor's report, and it looks like the government's commending that as an idea. Secondly, simplifying what goes into that report, so the actual contents themselves, and again, government seems to largely agree with that. There's some, what I describe as tidying up of various bits of untidiness in the technical aspects of charity property law, and again, government largely agreed that. Interesting enough, on the connected person point, and there was a little bit of radical thinking here from the Law Commission, specifically on the question of whether a trading subsidiary, a disposal by a charity to a trading subsidiary, need not go to the Commission for approval. Interestingly enough, the government, possibly having actually consulted further with the Charity Commission as well, isn't so happy about that. So the trading sub-elements will, as far as the government is concerned, needs still to have that Charity Commission involvement. Also, interestingly enough, on an aspect which actually I think most of us in the practice viewed as a fairly technical aspect of the law, which is designated land notices. This is where land is held for a designated purpose. The notice provisions related to that, which the Law Commission recommended be removed, largely because they frankly rather get ignored and missed out rather than honoured, more in the breach than in the honouring. They're keen to see those preserved, possibly because, of course, the government looks at that sort of land, certainly land that's held by government, quite often with that sort of public benefit perspective, and they're very keen to see the public being given opportunity to comment. So, interestingly enough, that one that they're not minded to agree. And on what I think we viewed as the slightly more radical element of the recommendations, which related to the charity disposals, what those who are in the game recognise as Section 1173C disposals. In fact, the Law Commission recommended a tightening up of the restrictions here, so that if a charity, for instance, was looking to dispose of, say, a lease to another charity, largely for a charitable purpose, but still taking a rent from that tenant charity, then at the moment that disposal falls outside the general regime requiring qualified affairs reports. In fact, the Law Commission recommended that such disposals should only be effectively where they're absolute gifts, not where there is a mixed motive in the actual disposal. And that's partly on the back of the fact that the introduction of the social investment powers and restrictions in the other parts of the earlier legislation had already anticipated that sort of mixed motive type of investment. So they're clearly pushing and keen to push charities towards applying the social investment rules in relation to anything that's mixed motive, partly being done for charity, partly being done for income. So interesting that that's remaining supported and coming through. Of course, all this doesn't mean we have law yet. The law is still the law as it is now. So all these qualified affairs reports as they existed under the old 2011 Act still continue to apply, unless and until a new Act is introduced. And when that is, again, that'll depend on government time and or going through the speedier process, which there is for non-contentious bills. Whether this one is viewed as a non-contentious bill, who knows? So government will have to get the revised legislation through Parliament or through the parliamentary motions. And when that is, there's an awful lot of other things that the government's going to be looking at post-COVID, post-Brexit. So I still think this is going to be a way ahead before we actually see any change to the law. But interesting and very timely that today, after yesterday, we know now what the government thinks about the Law Commission report. So, a quick run through the Law Commission element, which I thought was going to be a very, very quick reference, but that's where I'm at the moment. Happy again to pick up on any thoughts on that later if you've got any queries. So going on to the next item on this particular slide, which is residential long leasehold type transactions and law. And I say the end of the ground lease. This is perhaps not greatly relevant to many charities and religious charities, but it's surprising how often one comes across either with where one has a tenant who's a tenant of a long leasehold, or other arrangements that actually incidentally come into play for charities and religious charities. So worth just a review of how the law is looking like it's going. Broadly speaking, this comes out of the concerns that have been expressed in Parliament, in the public, about, frankly, the fast and loose behaviour of residential house builders selling houses on long leases. It's been in the press, I'm sure you're familiar with that. In particular, the Competition and Markets Authority are indeed very currently in review with various house builders over unfair terms in contracts and leases, and it's clearly part of government policy to try and inhibit what's been some, frankly, fairly rapacious behaviour by some of the house builders. As ever with these things that affect from that side of the market, if you change the law, then it has unintended consequences and affects others. Broadly speaking, it looks like ground rents are potentially going to become things of the past, or at least be quite severely limited. Also, the Law Commission as well is involved in this and has given recommendations on that, but also recommendations on easing the ability for long leasehold tenants to enfranchise, that's effectively buy out the landlord's interest from the landlord, and to do so on improved terms. Indeed, the Law Commission was actually asked to look at this positively with a view to improving the condition for tenants. So if you as a charity happen to have had a bequest, which includes the ground rent, as it's called, the freehold reversion to some residential long leases, you may well find that what looked like previously something where you might get paid a fair sum for the freehold reversion, and that's a value for you. That fair sum may look like a less fair sum in future, as the intention of government at the moment and policy is in the direction of making it easier for tenants and cheaper for tenants to acquire their freehold reversions. The last point there, common hold, this will be something which I doubt will ring many bells with many people, but gosh, back in 2000, I think it was, the idea of common hold as a whole new way of holding land was introduced. Frankly, fell on its face. There are one or two common holds around the country, but basically because the banks refused to fund any arrangement which involved a common hold because of problems over security. This method of holding law really went nowhere, but it's rather interesting that the commissioner who's been involved in the enfranchisement law has been very keen on the idea of common hold coming back, unless and until they've answered the questions over the bank's worries about taking security over common hold interests. It's going to be hard to see how this is going to work in practice, but watch the space. There is the possibility of that coming back into play again, and that can be quite interesting. It's a as I say, a new interest in land, which is a very, very big deal. On to the next one then, residential tenancies, end of the AST, crikey, end of everything at the moment, isn't it? Well, this is coming to the question of the notice periods that was mentioned by Catherine, the 2-month notice, no default notices, which are basically the essence of a short shortfall tenancy. That's what has driven ASTs being so popular as a vehicle for doing tenancies, housing tenancies for individuals who pay a rent on a periodic basis. For various reasons, again, frankly, rapacious landlords who have misbehaved, there's been quite a groundswell of opinion driven by tenant bodies, and I can understand that, where you've been abused by a landlord in the way that they have used those 2 months notice or 2 months notices at the end of the lease period, to seek to remove the ability in general for landlords to be able to exercise those what are called Section 21 notices. So if we remove the ability for a landlord to serve notice, 2 months notice, not having to find any ground for possession otherwise, then that really is the end of the AST. The whole point of the AST was the ability to be able to bring them to an end. It was an open contract, openly entered into. The tenant knew that they had at least 6 months worth of accommodation, and then beyond that it was a 2 month notice, and of course the tenant themselves could serve notice as well on the landlord. Now there's quite a lot of noise about this, and it was a little bit of a sort of political football at the time. You may recall that under the May government this became quite a thing that was being used possibly as part of the election process for the then election that came along. But the Renters Reform Bill, which was put in as a private member's bill on in relation to introducing that, I understand keeps getting delayed because it does obviously have a lot of pressure back against it from landlord groups. If you want my view on this, I've always thought, I've always observed that I thought that was probably a rather heavy stick for what was the issue. The issue seems to be giving certainty to residential tenants who need to be able to know that their kids can go to school, therefore they've got a tenancy that it will last a long time. And the answer for that is not necessarily to remove the ability to bring a tenancy to end on just notice, but to extend the period, and at the moment 6 months, under which the landlord knows that they cannot use that 2 months notice period. So if you can say, fine, you have the certainty of occupation for a year, 2 years, whatever period you like, but after that, the landlord can bring this to an end with a 2 month notice. Surely that is the more practical way of addressing the problem that's of concern. Because in fact, the idea of the Renters Bill is that there'll be a whole host of other grounds of possession that will be introduced. And that can make what is at the moment a relatively simple arrangement really rather complicated. So I'm not convinced myself that's the ideal route is to remove those 2 months notices period. But the fact is that that's what's in play at the moment, and we'll see if that Renters Reform Bill actually sees the light of day or something else comes out. But it's still there in play, just in the long grass at the moment. Last one on this particular slide is business leases. Now this is basically a government announcement that's rather sort of tickled the fancy of and excited various of the professionals in the area, talking about reviewing business tenancy law. Now this is quite a long time since this has taken place. The current legislation, which is the relevant core legislation, goes back to 1954, but seems to have worked fairly well and people are fairly familiar with it. But the thought is that the government is considering reviewing all of that. Again, the whole new world of post-COVID scenarios and post-Brexit scenarios, you could say as well, but particularly post-COVID scenarios, are making all areas of property law ripe for review. And certainly the rights of renewal are being looked at, we are told. This is all really just, I say, government hints and announcements. But also the way rent and rent review models work, that seems to be in play as well. And broadly speaking, they said reviewing business tenancy law in the context of the impact of COVID. So quite understandable, not perhaps a surprising thing given the age of the legislation, but an exciting prospect. And at the moment, no more to be said about that than that. It is coming. It will come at some point, I'm sure. So can we go on to the next slide, please? So I'm not going to do anything seriously about the tax relief review, as you've got the very good friends and experts at Buzzacott to come in a moment to talk about most of the financial and taxation issues. Safe to say the SDLT reduced rates running now till 30th September have obviously been a very, very serious thing. And one other comment on tax relief review. We're aware that in Scotland, charging rates on independent schools is coming. So if any of the faith bodies here are involved in independent school, and there are some who are still, then there has been and continues to be a question as to how that might be addressed in England and Wales as well. There was even noise about VAT on school fees. I think that's gone away for the moment, but there's always the open question mark as to how taxation works and the tax reliefs work for any charity which is fee charging. So anybody with a fee charging charity, there's always an open question in the background. I say no more than that. I'm not suggesting, by the way, that there is a general review on of charities relief. I haven't seen that out there, and indeed I wouldn't be the expert to speak about. So on to the next item, building regulation. This is really post-Grenfell. There's been a huge outcrying at the way that building regulation works in the country, and you'll see again very recently commentaries on how the cladding cost removal and reparations are to be worked out and how the cost of that to be shared out. I'm sure there'll be legislation coming on that. Particularly, I think, also the revisiting of the building certification process, which had effectively been outsourced in the years of Thatcher governments from what had previously been effectively a regulatory condition which was run through government. So I'd be very surprised if we don't see a review of that in some detail, and the general building safety rules that have become more lax. There's always a wave in these things, cycles in these things, and at the moment I think the world views our regulation at the moment is a little bit too light, and I imagine that we're going to see a tightening up of that. And on my other, what are my others? Couple of ones here. First of all, energy performance has been mentioned earlier. There's an alphabet soup of initials here. So EPCs, MEES, that's energy performance certificates and minimum energy efficiency standards for buildings. These are the things that you may recognise you need to have when you're disposing or letting a property. And at the moment, it looks like the steady upgrade of the expectation of the energy efficiency of buildings is going to push probably residential properties to need to have a C and better by 2030, and non-residential properties to have a B or better by 2030. Now it's 2030, it's way ahead, but these things are inevitably going to be upgraded. I'm sure that's coming. An immediate one just to have in your eye line is the electrical inspection condition report. That's the EICR. And you may recognise if you've been letting any properties, residential properties, that you need to have had one of these for doing a new letting for a while, but these will apply also to old lettings, existing tenancies, as of 1st of April. And these are all basically about having certificates, many of which most good landlords already will have, but be aware that you need to have them available on basically a 5-yearly basis, and that applies to existing tenancies as of 1st of April. Anticipating similarly on tenancy safety, carbon monoxide duties are likely to extend so again, having tests in place and having machinery within buildings you're letting in place to have a care for that. I won't say any more about planning law other than it's likely there's going to be further, I would imagine, developments on that in light of the huge effects on town centres and the like that COVID's caused. And to mention briefly also, there are some Welsh tenancy law changes. If anybody listening has property in Wales, then there is a bit of a divergence, increasing divergence of the land law between Wales and England. So watch out for those. Mostly name change, but actually some material changes to how particularly residential tenants are protected, with greater protections aimed in Wales than they are in England. That's how I will leave things and pass you over now to Amanda. Look forward to picking up any questions you have. Thank you.
Many thanks, Hugh. Good morning, everybody. I'm going to touch on some of the financial considerations. I'm going to try and make the talk that I'm going to give over the next few minutes as practical as possible. So apologies if I'm basically talking about things that you already know, but my experience tells me that where things go wrong with building projects, finance is not far from the cause. I'm then going to hand over to Sock, who's going to talk about some of the VAT implications. So let's go into my first slide. Today is designated a day of reflection because, as Tim said in his introduction, it's exactly a year since we all went into some form of lockdown. And if we look back on those 12 months, an awful lot has changed. And now probably is the time to reflect not just on the people that we've lost and what COVID has meant to people's lives, but to reflect on where we're going in the future. One thing is certain, the future will be different to what it was pre-COVID. To use that horrible phrase, there will be a new normal. And what I'm encouraging everybody to do who's listening in today is really to think about what those changes will be and how they will impact on you. So if I think of some of my clients, some of my religious congregation clients, I'm aware that some of you will have lost members a lot earlier than you had hoped. Some of you will have people who are going to continue to struggle, either because they have aged much more quickly than we had anticipated. Perhaps they have health issues and mental health issues, part of which, of course, are caused by COVID. On the other hand, some people will actually have flourished. They will have seen this as an opportunity to do things that they never thought possible, particularly given the changes that we've had with technology. So, you know, if you're involved in some form of ministry that's counselling or spiritual direction, I'm aware that some of my clients have found that that can be done slightly differently, but it can be done online, and there is the ability to reach a far greater number of people than had ever been deemed possible before. So what are the questions that I think you should be asking? I think you need to step back and say, well, where are you now? And importantly, where do you want to be in 5 to 10 years' time? Now, they may seem very long-term horizons, but 5 to 10 years when you're talking about property planning is a relatively short period. And the types of questions I think you need to be reflecting on are how many members of your congregation or how many members of your staff do you require to accommodate in the properties that you have? Where does that accommodation need to be located? So if you're spread across the country geographically at the moment, is that appropriate going forward? Do you need to bring yourself so that you're concentrated in a smaller area? And importantly, if you're a religious congregation, what are your future care and ministry considerations? So with regard to care, what type of care will you be needing to actually provide within the accommodation that you have? Where will individuals' care needs actually be catered for? Do you want to keep people within their own homes? Do you want to have a care facility, or do you want to suggest that your members go into care facilities operated by other organisations? I'm also aware that some congregations, their members are falling not because they're passing away, but because members want to move. They want to go back home, say to Ireland or to other countries. And that obviously will give rise to you thinking about the type of accommodation you need and the type of ministry that's going to be carried out within that accommodation. So what form should that accommodation take in terms of the size, the location, etc.? Now, many congregations still have very significant property assets. Those property assets are probably going to be substantially in excess of what you need going forward. What I would say about a property asset is it's what I would call an enabling asset. So it's not a means to an end in itself, but it's an asset that enables you to live your life as you want it to live. It enables you to provide accommodation for yourselves and for others and for your ministry. So when you're thinking about those assets, I think there are three questions. First of all, given that we're looking at 5 to 10 years, are you content that your property assets support your strategic plan or your ideas going forward? If you're not, do you look at your existing properties and think, well, they need to be altered in some way? They need to perhaps have ensuite facilities installed. They need to be enlarged. They need to be made suitable for people who perhaps have mobility issues and so on. Or possibly you look at your properties and say, well, they're not really suitable, but they do not really lend themselves very easily to modification. So perhaps they are unsuitable for future needs or surplus to future requirements. And therefore there's a thought as to whether you hold on to them and use them for investment purposes or whether you dispose of them. So let's look at the next slide and let's think about perhaps some of those properties you do believe are suitable for your own needs, but only if they are refurbished, if they undergo significant alteration or that there is an extension built. Now, you've heard already in today's seminar about the need to think about planning, the need to think about timing of those changes, but importantly, you also need to think about the financial implications and whether actually it makes sense to carry out that refurbishment and modification, or whether you'd be better looking to sell and purchase a property that is much more suitable to your needs going forward. Now, some of the direct cost implications that I'm thinking that you need to give consideration to, I've got on this slide. One of the things that often is forgotten when you're looking at the cost implications of a major refurbishment are the professional fees and VAT. VAT, remember, can be as much as 20%, so it can add significantly to the cost and possibly make it something that you think again about as to whether it's worth it. Think about if you have a major project, how you're going to pay for that project. What is the timing of the payments that you will need to make and the implications that they have on your cash flow? Will you, for example, have the money already in your bank account, or will you need to raise the money, perhaps from your investment managers? And if it's that latter case, you need to be thinking about, well, we should be having a discussion with our investment managers, particularly given the state of the investment markets and their volatility at the moment, and thinking and making sure that they're aware that we are going to need to realise some of our money from our portfolio. The other thing with regard to cost is overrun, and overruns often happen because of variations to the original contract, because as you start the project you think, well, wouldn't it be nice if we did this as well? They go over because there are problems with the project that weren't anticipated at the original planning stage, and there are overruns because of building issues. And obviously what we've seen over the last year are overruns caused by the lack of the building trade to work as efficiently as perhaps they would normally do, although it is one of the industries that has kept going throughout the last 12 months. One of the things that I know from my own experience as a trustee of a charity that has built 3 care homes over the last decade is that building projects often don't go well in the end stages because there are often disputes and discussions about the price. And one of the things that I would firmly suggest, if you're carrying out an alteration or an extension that is of any significant size, don't try and manage it yourselves. Don't try and do all the liaison with the various different individuals that have to be involved, such as your professionals and your construction company. Think about bringing somebody in who can project manage it for you and take take off all of the hassle and all of the difficult decisions and simplify them for you, so that you only really need to get involved at the high level stage. It will cost money, but believe me, it's worth its weight in gold. The other thing that I would absolutely suggest if you're carrying out this sort of work in terms of minimising cost is to invest in the planning stage, to think about what it is you actually want to do with your property. It sounds obvious, but you'll be amazed at the number of people who, as a project continues, are continually modifying their ideas. And that is frustrating for the builders, it's frustrating for your professional advisors. So talk to them at the outset, make sure that they are fully aware and understand your needs, that they understand the environment in which you work, that they understand the thought that you've given to where you want to be in 5 to 10 years' time, and that they can also advise you on those aspects. And think about how you're going to actually agree to the work that's going to be carried out. I would always suggest that you have a small working party, trying to agree alterations to a property when everybody has to have some involvement, and they will bring different ideas to the pot. It becomes very time consuming. You need a working party and you need the ability for that small group to make decisions. Timescale, building projects always take a lot longer than you anticipate. So given where many congregations are, time may be of the essence. So do start to think about this sooner rather than later. There will be delays. There may be delays because of planning permission being refused. That obviously may be adding to the cost as well. And the other aspect to think about is, if you're living in this property now, do you want to live in a building site? Will you be allowed to live in a building site? So if the answer to those is no, are you going to look for alternative accommodation whilst that work is underway? And where will that accommodation be? How much is it going to cost? Is it suitable for your needs? You know, does it suit your IT requirements? Does it have parking available to it? Is it a property where you would be allowed to have visitors? Are there restrictions on the use of that property? And so on. And the other thing that I'm going to hand over to Sock in a moment to talk about is, with any form of a refurbishment or alteration, there are significant VAT planning issues to think about. So I'm not going to touch on that, but I will hand over to him in a moment to discuss that. Before I do, though, my last slide is just looking at, if you take the decision that actually you're not going to refurbish yourselves, but you're going to look for alternative accommodation and to sell, or you're going to retain the property but allow others to use it, so find tenants and receive a rent for that. So let's look at that latter one first. So let's assume that you are going to retain it as an investment property. That's not a decision that I would suggest you take lightly. There are significant implications of doing so. Many of them are cost implications. The first one is the obvious one. If you are going to retain a property, the money tied up in that property is going to remain as capital. You're not going to be able to release it and to invest it or to spend it. So think about whether you actually need the capital from that property in the next 5 to 10 years. Again, property sales can be slow. So it's, you know, something to think about as to whether this is a long-term investment property or whether in the next decade you are going to need to release the money tied up in those bricks and mortar. The other positive, of course, of using it as an investment property is that you will get a rental income from it. But the downside is that you have to manage that property. It is still yours. So you will have to have a relationship with the tenants. So you will need either a tenancy agreement or a lease, and you will need to maintain that property or ensure that it is maintained. So again, there will need to be ongoing repairs. There will need to be ongoing communication with whoever is the tenant in that property. You might therefore think about using property agents. Therefore, there will be a fee to pay for them managing the property on your behalf. And as Hugh has outlined, and Catherine, there are a number of legal implications about investing or allowing one of your properties to be used as an investment property. There may be also implications for your broader investment strategy. So if you haven't got property at the moment that you allow to be used as an investment property, but you have a listed investment portfolio, if you do convert one of your properties to investment property, talk to your listed investment managers as well, because they probably will want to avoid investing in property companies in order to maintain the balance on your broader investment strategy. And finally, if you do decide to sell, it might well be a straightforward disposal. So you might just simply put the property on the market and sell it relatively easily. Remember that because you're a charity, you do have to be compliant with the Charities Act, and you do need to get that surveyor's valuation and report done before you can actually dispose of it. As was outlined in the talk from Paul this morning, you may on occasions sell a property for less than full price, but there are very strict conditions on when you can do that. So selling to another charity whose objects are consistent with your own and so on. So if you do want to sell a property for less than its full price and you have a potential purchaser, think very carefully about whether they comply with those requirements. And finally, just two areas to just be wary of. First of all, if you have a property which you are selling and the likelihood is that the purchaser will be purchasing it for development, they might want to discuss a potential way of buying it whereby they perhaps give you an initial payment, but then they give you some deferred payment, which is based on an overage calculation. Now, what we mean by an overage is that you share in some sort of uplift in the value of that property or in the developer's profit. Now, overage is one of those areas that you need to be extremely careful of because it will be possibly taxable because it's covered by anti-avoidance tax legislation. So if you have a developer who's purchasing your property and they want an overage agreement with you, do before you sign any contract, talk to your professional advisors to ensure that you're clear on what the tax implications are. Very simply, in simplistic terms, it's far more complicated than this in reality, but in simplistic terms, if your overage calculation is based on an uplift in market value because of planning consent that's obtained by the developers, you are unlikely to have to pay tax. Whereas if the overage is based on the profit that the developer makes when they subsequently sell the property they've constructed, that is likely to involve a taxation payment. And finally, I'm aware that many charitable trusts at the moment are converting into CIOs. Do be careful if immediately prior to that conversion you have a property that is on the market or you are even seriously considering disposing of a property. Because if you were then subsequently to transfer that into a CIO and the CIO were to complete the sale, it is possible that the CIO may have to pay stamp duty on that purchase. And that is because the CIO has purchased a property knowing that it's done so with the view to resale. So they're just a few of the areas to be careful about. I'm now going to hand over to Sok, who's going to talk about the more complicated area of VAT.
Oh, thank you, Amanda. Okay, yeah, as a starting point, next slide, please, sorry. As a starting point, ordinarily, VAT on refurbishment of existing buildings, the construction services you're going to incur will be liable to VAT. However, there are some specific zero rate reliefs, and I should caveat the position and say that for every zero rate relief that you're considering, there are always specific conditions applicable to that particular relief. So I'm only going to touch on this at a very high level. So the first one to be aware of is the installation of ramps or the widening of doorways or passages for wheelchair access. If you're undertaking that type of work, there is a particular zero rate relief whereby you don't have to pay VAT. Extending or adapting bathrooms, washrooms or lavatories. As long as the works are for disabled persons in a charity residential building or a daycare centre where at least 1/5 of the users are disabled, then again, zero rating can apply to those services. The installation of lifts in a day centre or a building that's for temporary or permanent residence for disabled persons, again, there's a particular zero rate relief for those kind of works. And then finally, alarm call systems, where a charity is making these available for disabled persons for either their personal or domestic use. Again, there's a zero rate relief for that kind of work. And I should add that preparatory restoration or making good any works in relation to any of those reliefs that I've just very, very quickly summarised can also be zero rated. So again, the best way of mitigating VAT, if you can, is to look and see whether there are any zero rate reliefs that you can use. And if you can use those reliefs, then that's the best way of reducing the potential VAT burden. In the absence of these reliefs, the works will of course be liable to that. Next slide, please. Now, Amanda mentioned extensions, enlargements and annexes. Well, ordinarily works to an existing building whereby you're either extending or enlarging it will always be subject to VAT, unfortunately. However, there is a specific zero rate relief for the construction of a charity annex. And we always have fun and games in trying to determine what is a charity annex. And there are three specific conditions that have to be met. The first one is that the annex has to be used for what's called a relevant charitable purpose. And that phrase there does have a specific meaning within VAT legislation. It's not what you or I might deem to be charitable. As far as HMRC are concerned, when we're considering relevant charitable purpose, the building has to be used either solely for non-business purposes, or it has to be used as a village hall or similarly in providing social or recreational facilities for the benefit of a local community. So the first thing that you need to consider is, what is my annex going to be used for? Do I satisfy the so-called RCP test? Once you get over that hurdle, the next test you have to satisfy is that the annex has its own independent main entrance. And that's quite an important factor, because the annex must have its own main entrance, and that main entrance mustn't become the main entrance of the existing building. The existing building must continue to have its own main entrance. And then the last condition on there is that the annex must function independently of the existing building. And this particular condition has been the subject of a number of tribunal cases. For example, the kind of thing that you would ask yourself is, does my annex have its own kitchen? Does it have its own washroom and lavatories? In fact, there was even a case where there was consideration as to whether the annex had its own heating system. So it's, again, very important when you're considering the zero rate relief, what are the specific conditions? Do I satisfy them? Slightly different to when you're constructing a completely standalone building, of course, where there is a particular relief where you've got either a new dwelling or a new building that's used solely for relevant charitable purposes. When you're trying to get relief under the annex conditions, it's very important that you look at exactly what it is that's being constructed. And in fact, the use of the annex itself. If the annex is going to have exactly the same use as the existing building, again, you're going to get challenged from revenue, because revenue will likely argue that that's just either an extension or an enlargement, because the use is exactly the same. Okay, next slide, please. Now, if having considered all the zero rate reliefs, none of them apply, unfortunately, you're going to incur VAT at 20%. And if there's a 20% VAT cost, your next consideration is, to what extent can I recover any of that VAT? And it's a basic principle of VAT that if you incur VAT on costs, that VAT can only be reclaimed to the extent that you're using the building or the asset to make what are called taxable supplies, or you're using it for taxable purposes. So there's a few things that need to be considered there. First of all, if you're using the building for your own use, what is your use? Is there any taxable use? Can I have some or any VAT recovery? Do I have a VAT recovery method agreed with revenue? If I do, do I need to do something different for this particular building project? So as I say, the first point to consider is what's the extent of taxable use? Can any of the VAT be recovered? And you'll need to factor that into your budgets, because it's probably unlikely that you'll be able to get all of that VAT back. So that needs to be factored into your budgets when planning this kind of project. If you're intending to refurbish and let the building to a third party, then consider the option to tax. Ordinarily, rental income is exempt from VAT. The option to tax converts that exemption or that exempt supply into a standard rated supply. Why would you do that? Well, by making a standard rated supply, that gives you entitlement to VAT recovery and so reduces the cost of your project. However, before opting to tax, you need to consider a couple of other points. What's the impact on the tenant? Is that going to be an additional cost to them, such that they then don't want to take on that lease or enter into an agreement with me? If the tenant is going to be a connected party, there's strict anti-avoidance legislation that needs to be considered. What's the long-term impact? Once you've exercised your option to tax, it stays in place for a period of 20 years. So therefore, if at some point in the future you decide you want to dispose of that building, have you made your building less marketable because now you have an additional 20% VAT charge to apply, assuming of course the standard VAT rates remains at 20%. It could be long term, we may see that VAT rate increasing at some point. I mentioned disposal of the building. If you've opted to tax, then the disposal will be liable to VAT. Another issue to consider are the transfer of going concern provisions. So if instead of disposing of the building with nobody in it, if you dispose of a building with some tenants in there, so actually what you're doing is disposing of a business rather than disposing of an empty property, there is the TOGC, the transfer of a going concern provisions that might apply, which basically means you will be able to sell that building without charging VAT. Again, there are specific conditions to be met, but something that should be explored if potentially that might apply. I'm conscious of time. I'll hand over to Tim now to see if we have any time for Q&A. Otherwise, Tim will sum up.
Thank you. Well, unfortunately, we don't have any time for questions today because we've run over slightly. But thank you to those of you who have submitted questions. And as I mentioned at the beginning, we'll address all of those in a written follow-up that will come out in the next few days. So please keep out an eye for that, because it'll be accompanied with a copy of the webinar recording and also copies of the slides. So that all that remains really is for me to thank all of our panelists, Paul, Will, Catherine, Hugh, Amanda and Socrates, for their input, and to thank you all for joining us today. Thank you.